Gotcha. But he was going to go back to California.
All right, good afternoon, everybody. Judge Stamey here at the Polk County Courthouse. I can see the South County inmates. Now I see the Central County as well. All right, everybody, you guys don't have to stand up, but where you are, if you could just raise your right hand to be sworn in. You swear or affirm to tell the truth, the whole truth, nothing but the truth. If you agree, say I do. Everybody said I do, put your hand down. Do we have a juvenile? Is that that gentleman?
Yes, sir.
Okay. Mr. Hernandez, I'm going to read the advisory in English. When I'm done, could you please read it in Spanish?
Yes, of course, Your Honor. Good afternoon.
Good afternoon. Good afternoon, everyone. This is your first appearance hearing. A first appearance hearing has 4 purposes and 4 purposes only. First, I will advise you of the charge or charges that have been filed against you. Second, I will ask you if you have an attorney representing you. If you have hired an attorney and they are present, they will speak on your behalf. If your attorney is not present, you will have the option of proceeding forward with your hearing today or postponing your hearing until tomorrow. If you postpone the hearing, it is your responsibility to contact your attorney to let them know you will have court tomorrow. If you wish to move forward without your attorney present, we can also do that. If you do not have an attorney, I will ask you if you can afford to hire one. If you can't afford to hire one, we will make note of that and we'll move on with your hearing. If you cannot afford to hire one, and if you qualify, I can provisionally appoint the Office of the Public Defender to represent you pending your formal filling out of an application. You have a right to have your attorney present before and during any questioning. Third, if there are any challenges to probable cause, I will address those challenges. And finally, I will review your bond and/or bonds or other release conditions with you to determine if any changes are needed. Be aware that this court places you on pretrial release today, regardless of whether it is straight pretrial release or as a condition of your bond. The conditions announced in court today go into effect immediately, meaning even while you remain in custody. For example, if you are told to have no contact with a certain person, let's just say the alleged victim, and you call that alleged victim from the jail before you are released, you are and will be in violation of your pretrial release conditions. Throughout this entire process, you have a constitutional right to remain silent. If you choose not to remain silent, anything you say can be used against you. Everything that is being said where I am located here at the courthouse, as well as where you are located there at the jail, is being recorded. There is also an assistant state attorney present listening to everything that is being said, so do not say anything about the crime itself. Please keep these rights in mind as we go through the process, and please step forward when your name is called.
Buenas tardes. Estamos hoy aquí para una audiencia de primera comparecencia. Una audiencia de primera comparecencia tiene solamente 4 propósitos. Primero, le informaré cuáles son los cargos interpuestos contra usted. Segundo, le preguntaré si ya usted tiene un abogado que le represente. Si usted ya ha contratado a su abogado privado y él o ella está presente con usted en esta audiencia, hablará por usted. Si su abogado no está presente en esta audiencia, usted tiene la opción de proceder hoy con su audiencia o de posponerla para mañana. Si usted decide posponer la audiencia, será responsabilidad suya comunicarse con su abogado y hacerle saber que usted tendrá una audiencia. Nadie podrá hacer eso por usted. Si usted desea proceder sin su abogado presente, puede hacerlo. Si usted no tiene un abogado, yo le preguntaré si tiene los medios económicos para contratar uno. Si es así, haremos una nota de esa información y procederemos con la audiencia. Si usted no tiene los medios económicos suficientes, yo puedo asignar a la oficina de la Defensoría Pública para que le represente a usted, esperando que usted llene una solicitud. Usted tiene derecho a que su abogado esté presente con usted antes y durante cualquier interrogatorio. Tercero, Yo me ocuparé de resolver cualquier recusación presentada con respecto al motivo probable de su delito. Finalmente, revisaré con usted la fianza o las fianzas y otras condiciones de libertad condicional que hayan sido impuestas hoy, sin importar si es una libertad condicional sin pago de fianza o las condiciones de su fianza. Las condiciones que el juez anuncie hoy entran en efecto inmediatamente, aun cuando usted se encuentre en la cárcel bajo custodia. Durante todo este proceso, usted tiene el derecho constitucional de guardar silencio. Si usted elige decir algo, cualquier cosa que usted diga puede ser utilizada contra usted. Todo lo que se diga donde yo me encuentro, así como donde ustedes están, se está grabando. En la sala del juzgado se encuentra presente conmigo un fiscal asistente del Estado, escuchando todo lo que se dice, de manera que por favor no diga nada sobre el delito en sí. Sírvase tener estos derechos presentes a medida que avancemos por el proceso. Por favor, cuando se llame su nombre, colóquese frente al podio. Gracias. Thank you, Your Honor.
Thank you, Ms. Hernandez. I do see Ms. Stewart's joined us. Good afternoon, Ms. Stewart. Let's go ahead and do our one Creole interpreter case. Let's
Good
call
afternoon,
up
Your Honor.
Roldine Osman, Osmene.
Uldinos Med,
Oui.
yes.
Yes.
You've been arrested on one charge of leaving the scene of a crash without giving what the law requires as far as information.
Je t'ai chargé de un crime que ou t'es quitté une scène de accident sans que ou pas de bail sa loi li mande.
Oui.
Yes.
Ma'am, are you going to hire a lawyer or do you want me to appoint the Office of the Public Defender?
Madame, est-ce que vous pouvez employer propre avocat pour ou soit vous avez même appointé un avocat de service public là?
Da me appointé un avocat de service public là.
I would like a public defender to appoint me.
I'll provisionally appoint that office to represent you.
Je vais appointer officier en provisionnel pour représenter vous.
I have reviewed your affidavit from the sheriff.
J'ai révisé affidavit là dans le département shérif là.
I do find probable cause for that one charge,
Et m'te joint cause probable pour une charge ça.
and I'm setting your bond at $250.
Et m'a mette caution en bon nan de $250.
Have a nice day, ma'am.
Passez une bonne journée, madame.
Merci beaucoup.
Thank you so much.
Ms. Stewart, I don't think there's anyone else, but you certainly are welcome to make an announcement.
Thank you, Your Honor. I'll make an announcement. Est-ce qu'il y a quelqu'un qui a besoin d'un interprète en créole? Si oui, dis oui, ou soit levez main.
All right, I see no hands. Thank you so much, Ms. Stewart, for being here.
Thank you, Your Honor, and have a great rest of your day.
You do the same. If you gentlemen don't mind, can I get the juvenile out of the way, and then I'll call you guys next. Our one juvenile is Cameron Solomon.
Stand up.
I'll ask to be heard on this one, please. Good afternoon, sir. You're here having been arrested for the charges of aggravated battery with a deadly weapon and tampering with physical evidence. Do you want me to appoint the public defender to represent you?
I already have them.
You already have an attorney, you believe?
Yes, sir.
Let me just turn to our clerks and just make sure they agree with you. I'm not doubting you. I just want to make sure that our paperwork is accurate. Do y'all show an attorney that's on this case? And Ms. Smith, if you, sir, do you remember, is it a public defender or did you hire one?
My mom hired one.
Okay.
Yeah, I don't see notice of appearance.
Yes, sir. Just so you know, and I don't know, I assume your case got, it's a direct file. Maybe it came through another court. We don't have any notes that reflect that, but if you know you've hired an attorney, and if anything changes, you can always ask for a public defender later.
Yes, sir.
Okay, I've looked over, in your case, there's a direct information, meaning the state attorney has already filed formal charges. As a result of that, the clerk's created what we call a capias. It's a bench warrant. From these documents, I find probable cause for the two charges. Let's hear from Mr. Matthews. He wants to be heard as it relates to bonds.
Thank you, Your Honor. May it please the court. Regarding the Top County aggravated battery using a deadly weapon, the state is filing a motion for pretrial detention. It is charged as a second-degree felony. So it is a qualifying dangerous offense. It's enumerated. This would proceed under 907-0415C. Can I approach, sir? I respectfully request the court review that motion, and if it is found facially sufficient, that the accused be held no bond pending a hearing on this motion, which should be set next Monday at 1 o'clock on the A2 docket. Thank you.
Ms. Smith, anything from the defense on this one?
I don't know who, does he know the name of, do you know the name of your attorney? He doesn't know the name?
I do not show one in staff.
Okay.
Yeah, I didn't know if this came through, like I said, the juvenile courtroom and it got filed. I don't know if it's hired him.
All I can say is at least in, for as far as adult record, he didn't have any prior record for adult record because he's not an adult. I would point out that the actual capias that the state issued said no bond until first appearances on it. And then on the actual capias, it was changed to just no bond. I understand they filed a motion. I would just refer to the court.
Yeah, but did you say the first thing said no bond until first appearances? I have the capias and it just,
Well, the capias never, the thing is, I've probably talked to clerks about this before, but it hasn't been straightened out yet. It says on the capias, it says no bond, but
right,
it shouldn't say that. Actual issue capias that the state filed, Karen Burnett on April 24th says no bond until first appearances. But for some reason, their hardware, their computer stuff will not allow them to put until first appearances for no bond. I think they have limited space or something, but there's some reason it doesn't say that. So you always have to be careful with these because it may be a no bond until first appearances and just that they can't put the until first appearances on the actual capia. So I always have to look out for that. That's all I was bringing up.
all right, Mr. Solomon, I have reviewed the state's motion for pretrial detention. It's filed pursuant to Florida Rule of Criminal Procedure 3.132 and Florida Statutes Chapter 907.0415C5. I reviewed this document. I find it to be legally and facially sufficient. As a result of this and the law that it's based on, I am going to hold you no bond on the charge of aggravated battery. And we're going to send you over to see the circuit judge, the A2 judge, on May the 4th. That's next week. On the charge of tampering with a physical evidence, I'll set your bond at $5,000. Have a nice day, sir. And let your attorney know you have court on May the 4th. You said that amount was, for that date was, I'm sorry. Yeah, 1 o'clock on May the 4th. If your mom ended up not hiring an attorney and you change your mind, you can always ask for a public defender on that day or send word to the public defender's office through the jail mail that you want to be appointed a public defender. They can always file a motion. But you said you've hired an attorney. We'll let you do that. But if you change your mind, we can always appoint the public defender later. Any questions?
Yes, sir.
Have a great day, sir. Mr. Tribblade, you were here first. Why don't you pop up here and we can do Mr. Norgard next.
Thank you, Your Honor.
I believe yours must be Crosby.
Yes, Your Honor. Church on behalf of Albert Crosby.
Albert Crosby, and I'm sorry, Madam Clerk, I see you there. I'll get you 1 second. My apology. I'll get you next, in fact. My apologies to Mr. Norgard. Mr. Crosby, you're here on 8 different charges.
We wait reading.
And they're all appear to be third-degree felonies. Mr. Tribble, you representing him on this case?
Yes, Your Honor.
Okay. Any probable cause challenges?
No challenges to probable cause. This looks like it was a direct file with the KPS, Your Honor.
It was, yeah. I see the information in front of me with all 8 charges. and I see that KPS that was generated. Oddly enough, I guess it's rooted in the way they came in the door. The state ultimately filed 8 different charges of the same statute, but it looks like they came in the door something different. And so I guess that's why on 2 of the charges, there's a bond and the other 6 are not.
Yes, sir.
Have you heard as it relates to bonds?
Your Honor, as it relates to bonds, this here is someone who has a history of being a Lakeland resident. There are suggested bonds in the amount of $5,000 for 2 of the counts. We request that the court set a reasonable bond.
Mr. Matthews, anything from you? My intention was to set them at the 5,000 per count. All right, sir. Finding probable cause based upon the paperwork. They're all 3rd-degree felonies. Standard bond is $5,000 per count. So you add it all up, that's $40,000. Have a great day, sir.
Thank you.
Thank you, Judge.
You bet. Good to see you, sir. All right, let's real quick, since we have our interpreter, let's call up Tang Hong Koon.
I'll ask you on this one.
Hong
Your
Koon
Honor.
Chang.
And Your Honor, Sanderson, Public Defender's Office. I normally waive the reading of the charge as the first appearance.
Madam Interpreter, if you're talking, we can't hear you, so you
Good
might need to.
afternoon.
Good
Your Honor,
afternoon.
can the court hear me now?
Yes, ma'am. That, whatever you did helped, so we can't hear you. So we're going to pause to give you a chance to do your interpretations.
Thank you, Honor. I have not been sworn in today by the court.
Yes, ma'am. Raise your right hand. Do you swear or affirm that you will well and truly interpret English into Mandarin and Mandarin into English to the best of your abilities on the cause now pending before this court?
Yes, I do. Mandarin interpreter Yan Li for the record.
Thank you, Ms. Lee. All right, let's call up Hong Koon Chang.
好的，现在我们要叫的案子是陈宏坤的。
Ms. Smith, as it relates to the reading of the charges, your position is?
I would like to waive them unless he requests that the court tell him what the charges are.
那么一般情况下呢，律师是会放弃，就是说你要选择阅读的权利，除非呢你希望法庭现在告诉你你对你的指控是什么。
And I would point out.
什么意思？什么意思？
I don't quite understand.
I would also point out that the one charge should have an attempt in front of it. It should be a 3rd-degree felony instead of a 2nd-degree felony. And I mean, if he wants the charges read, so he knows what he's charged with, he does have that right. But like I said, I normally waive it, but due to the language barrier.
You want to ask him what he wants?
Mr. Chang, do you want the judge to tell you what your 5 felony charges are, or do you know what they are?
陈先生，你现在是否希望法官告诉你现在对你的这5项指控都是什么，还是说你已经知道了？那么刚才律师说的意思呢，就是说他一般是会不选择读的。
选择不读，我知道了。
No need to read. I already know.
Okay, thank you.
All right, sir. On these 5 separate felony charges, do you want me to appoint the public defender?
那么针对这5项不同的指控，全部都是重罪的指控，你是否需要我给你指派一个公辩律师？
我能选择找个律师吗？
Can I choose to appoint my own?
Sir, you can choose to hire an attorney that you pick, or if you go the public defender route, they assign who they want to assign to you.
先生，如果你要自己选择聘请自己的私人律师，你可以自己聘，或者呢走公共辩护律师的办公室，他们可以给你指派一位。
我想自己聘一个律师。
I would like to hire my own.
Yes, sir. You can do that, and if for some reason you change your mind, you can always ask for a public defender at any time moving forward on your case.
好的，先生，你可以这样做。那么当然了，在这个诉讼的程序中，如果你改变了你的想法，需要请一位公辩律师也是可以的。
我之后我可以给我的家人打个电话，让他们帮我聘一个律师吗？
Would it be possible for me to call my family so they can hire a lawyer for me?
Yes, sir. I think they'll make phones available to you there at the jail.
是的，先生，在监狱他们会给你把电话给你，让你打电话的。
好的，谢
Sir,
谢。
I've reviewed your
thank you.
affidavit that's been prepared by the Polk County Sheriff's Office.
我现在已经看了，就是 Polk 县给你准备的宣誓陈述书。
I find probable cause for all 5 of these felonies.
针对这5项重罪的指控，我发现确实是有合理依据的。
And to Ms. Smith's point, the 5th one on the list contained within the affidavit, I'll treat it as an attempt.
那么在这一个宣誓陈述书的这个清单上的第5项，我呢会把这一项作为一个意图。
Or a better way to say it, I'll treat it, I'm going to find PC only for the attempt, not for the F2.
那么也就是说，对于这一项，我们是把它看作是有意图的，而不是只是 F2的。
They like to be heard as it relates to bonds.
好，现在听一下检方。那么关于保释金，
Yes, Your Honor. With regard to count 5, an attempt of that crime is an enumerated dangerous offense.
好的，法官大人。那么根据我们刚才所说的这第5项，那么对于这第5项，它实际上就是已经有意图，而且是有试图进行这一项犯罪。
State is filing a motion for pretrial detention. May I approach?
Yes, sir.
那么检方现在呢是希望可以做一个审前的扣押。
State requests the court review that motion for facial sufficiency and if so found, hold the accused no bond until a hearing on this motion. It should be set for next Monday at 1 o'clock on the A2 docket. Thank you.
那么如果法官这边审理之后认为是有足够的依据，那希望我们是可以对这一位先生是进行审前羁押，而且是不准保释，一直到下一周一下午在 A2 的这个法庭我们进行庭审再做定义。
Anything from the defense on this matter?
听一下辩方。
No, Your Honor.
辩方没有。
He's a juvenile, so they did him first.
Sir, having found probable cause, I'll now set your bonds.
好的，先生，确实是有合理依据，所以现在给你设保释金。
I'm going from the top to the bottom as it appears on your affidavit.
那么按照你现在手中看的这一个宣誓陈述书来看的话，它是从上至下的。
On the first charge, a 3rd-degree felony, your bond is $5,000.
第一项3级重罪的指控，你的保释金是$5000。
For second charge, also a 3rd-degree felony, is $5,000.
对于第2项也是一个3级重罪的指控，对你的保释金也是$5000。
On the third charge, also a 3rd-degree felony, your bond is $5,000.
关于第3项对你的指控，也是同样3级重罪，保释金设定为$5000。
On the fourth charge, it's a 2nd-degree felony. I'll set your bond at $15,000.
那么对于第4项指控是一个2级重罪，那这一项的保释金设定为$15000。
And on the 5th charge, I do find this motion for pretrial detention to be legally and facially sufficient.
那么关于第5项，那么这一项的指控，我确实是发现对你要做这个审前羁押的这一个，我们是有足够的法律依据的。
Based upon me finding probable cause for the attempt,
那么基于我对你的这个意图以及你的试图实行犯罪已经发生是有合理依据。
and based upon the state's motion, I'm going to hold you no bond on that charge.
那么根据检方的动议提起，我呢会对这一项做无保释。
I'm going to send you to see the circuit judge on May the 4th.
那么我会让你去看巡回法官的法院在5月4号出庭。
So on that one charge, you have no bond, but you have bonds on the other 4.
也就是说，对你的5项指控中有1项是不予保释，有其他的4项是可以保释的。
Any questions, sir?
有什么问题吗
？4项保释的话，是不是这4项的保释金我交了之后，我就可以出监狱，然后4号再回来？
If I'm able to be bonded out on the 4 charges, does it mean if I pay the bond, I can leave and then I can come back on May 4th?
No, sir. As long as you have a no bond on any of these charges, you're not able to get out of jail until that changes.
先生，不是这样子的。如果你的指控中有一项是不予保释的，那你就在这期间都不能离开监狱，直到这一点变化为止。
So you can post the bond on the first 4, but they will not accomplish you getting out of jail as long as you have no bond on the 5th.
也就是说，你把前4项的这个指控的保释金都交了，还是没有办法离开监狱，因为你的第5项指控是有一个不予保释的规定。
But you get to talk about this, talk it over with the judge on May the 4th at 1 p.m. and that judge may consider changing the no bond.
所以呢，你需要在5月4号下午1点钟的时候出庭，然后呢跟法官看法官是怎么定，有可能这个法官会改变这一决定，你到时候要出庭。
Have a nice day, sir.
OK， 好的，祝你今天愉快。
Miss Lee, I think that's everyone. You certainly can make an announcement if you'd like.
Sure. 请问现在还有没有需要用中文翻译的？
I see no hands. Miss Lee, thank you for helping us today.
Thank you, Your Honor. Have a good afternoon.
You do the same. Mr. Norgard, you ready?
I am now.
You've waited long enough.
We brush up on my Mandarin.
You did offer to help us. Help. Did you go back to that, gentlemen? I want to make sure Mr. Cox was up here and I want to make sure you got them all correctly because your list is not the same as this list. And that's where I was concerned with Mr. Cox distracting you, that you didn't. And it's a challenge because I can't tell you. So let me go back and look at the ones we have here. Yes, sir. Why your 5 aren't listed the same way they appear at the jail, I don't know, but y'all choose to jumble them up sometimes. On your number 1, it's correct, 5,000. On your number 2, it's also 5,000. Your number 3 is 15.
And then the 4th is 5,000.
The 4th is 5,000. Yeah, those two got inverted.
And then the comments for the probable cause is also correct.
And then, of course, the number 5 is a no bond, correct? We just inverted those two with Mandarin interpreter. It was, if you're correct, it went from an F2 to an F3 based upon only PC for the attempt. Motion for pretrial detention, open court, correct. Motion for pretrial detention set for 5-4. Yep, everything's great. I think you just had those two flipped. All right. Let's call up Daryl Jerome.
Your Honor, in this case, if it's not already been filed, I am filing a notice of appearance to represent him in this case. We are aware and know what the charge is that he's charged with. It's just, we don't need to deal with probable cause because he was arrested on a warrant, but the warrant does provide that on, as you said, at the first appearance hearing, in consideration of release, what I'd like Your Honor to consider is that the registration requirement for him was based on a situation out of California. The case in California involved a misdemeanor, which, because of the nuances of how that works, he technically had to register here and had registered here and had it on his driver's license. But what happened is on September 27th of 2022, the court in California actually granted his petition to terminate sex offender registration. I'll show the court a copy of that order. And actually, that's an extra copy if you want to keep it. Where it gets tricky, Your Honor, is that although that was terminated in California, the originating state in 2022, under Florida statutes, which took me about an hour to plow through and find it, there is a requirement that even though California terminated it, because he had once registered and had a driver's license that designated it on there, he has to petition FDLE in order to have that removed from registration in Florida. At the time he was stopped by the law enforcement officer, when you read the arrest affidavit, the guy just simply told him he had to register in 48 hours. It wasn't until the detective went back, looked into it, and a week later, the officer looked into it a week later, he saw that he also had that termination in California. He looks up the law and sees that technically he still has to register in Florida, despite the fact that California doesn't care anymore. And so I would ask the court to, take that into consideration. If I'd have been able to challenge probable cause on this, the officer had contact with him at point A, checked back a week later, but never confirmed that Mr. Duran was actually still in Florida and subject to the requirement of registration. So I know those technicalities can be assumed sometimes or overlooked, but I've actually, as we're building our case, because he did not think he had to register and the police officers told him to do it. He's a truck driver and he'd actually left the state on a truck route. And I have receipts that he was out of state within the 48 hours. And I'd ask the court to consider that in setting bond and not overly burden him with a high bond and or conditions of pretrial release under these unique circumstances.
1 second, I'll see what Mr. Matthews' position is. Let me read this, jog my memory. Matthews, what's your position on this?
With respect, Judge, I think technicality is the term a lawyer uses to describe a law that they prefer not to have to comply with. My reading of the affidavit is that there is a violation of law stated, that there is probable cause. It also appears from the statement in the probable cause affidavit that the ties to the community may be limited. That being said, the defendant, my reading of it, is entitled to a bond, and I do not object to the court setting reasonable bond.
Just a couple additional things, Your Honor. Sometimes technicalities are hyper technicalities, and apparently even the law enforcement officer did not know it until he started to research things and found it out. When you go through the sex offender registration laws, Your Honor, it took me an hour last night to find this buried in all these nuances with references to this section and that section. He had a document saying he was no longer, terminated in California. And I think to some extent, a layperson's going to rely on that. I would also point out that although Mr. Matthews claimed tenuous ties to the community, he does have a Florida driver's license, but he also, when he found out about this warrant, contacted me last week. I advised him what he needed to do is come back to Florida and turn himself in, and he did. And he turned himself in yesterday evening, and here we are.
My inclination would be just to the $5,000 cash or surety. What concerns me a little bit about what you're saying about his employment, the circuit judge that signed the warrant wants him to be on a curfew. So a little bit, knowing that he's an over-the-road truck driver, a curfew might not be something that is going to jive with his employment. I don't really know how I'm going to be able to get around that. The circuit judge signed the warrant saying this is what she wants to have it done. I don't really feel comfortable ignoring what she wants. certainly you can try to get back in, or whatever judge is assigned to the case, you can certainly get in front of them as quickly as possible, but I just don't know any way around that one, whether I lower the bond, raise the bond, set a standard bond, that curfew seems like it's going to be potentially problematic based on what you've told me.
Well, one thing I would point out, Your Honor, is this is a strange form to me, is it says conditions requested by law enforcement.
If you look over to the far right,
I see the initials.
yeah, that would be the Judge Hill, female Judge Hill's initials, where she, signed, she agreed with the police officer. The police officer wanted it, and she agreed by initialing off on the right, and then down at the bottom, conditions ordered and approved by the judge are conditions of pretrial. She checked X. That doesn't, she checked it yes. That doesn't just populate on its own, so she did that. So that's what I'm going to do. I certainly understand your argument. I'd probably be a little bit more sympathetic to him if it wasn't for the police officer giving him the 48 hours. The policeman said, hey, you didn't do what you were supposed to do. I'll give you 40 more hours to make it right. And it doesn't seem like that happened.
Well, he left the state so he wouldn't have to. And the police officer didn't realize it had been terminated till he dug into it a week later. So
I'm going to set the bond at that 5,000 cash or surety, making it a condition of pretrial release. If Mr. Jerome post bond is released to the street, he has to immediately check in with pretrial services, sign up in person and call them on, I think Tuesday and Wednesday is enough. All the standard conditions, and the only special condition is Judge Hill wanted you to have a curfew of 10 p to 6 a. So I'm going to order that you be confined to your approved residence between those hours. And of course, whatever, I don't know if y'all know what division it's going to yet, but you can start, maybe if you need to get in front of that circuit judge to get hearing time.
yes, sir.
He's looking it up real quick to see who it is. Yeah.
Sometimes it'd be nice if they gave you a little more discretion, wouldn't
It's
it?
going to be
They heard more of the story.
Well, say that again.
It will be with F6.
F6, and who is that?
Judge Hill.
The other Judge Hill, not the female family law Judge Hill.
Talking right now.
Yeah.
They're now.
Gerald Hill is the one it's going to. I have this if you need a copy of it. Head that way now. You have it? Okay.
Yes,
You want this back?
It was an extra copy if you wanted to have it.
Nice to see you.
Good to see you.
Have a great day, sir.
On Tuesdays and Thursdays.
Yeah.
Tuesdays and Wednesdays.
Did I say, I'm sorry, Tuesday and Thursday?
Yes, sir.
Yeah, Mr. John, when you get out, give my office a call and we'll straighten it. We'll work on straightening out the whole issue of pretrial release, okay? We'll be in touch.
Have a great day, sir.
Thank you.
Good Lord. All right, I think we're now to our Spanish cases. We have 3 of them today. Let's call up David Almaguer.
David Almaguer.
All right. Sir, you're charged with driving while license suspended with knowledge. Do you want me to appoint the public defender?
Señor, usted tiene una acusación de manejar con la licencia suspendida con conocimiento. ¿Quiere usted que yo le nombre un abogado de oficio?
Sí.
Yes.
I'll appoint that office. I find probable cause. Your bond is $250.
Voy a nombrar esa oficina. Encuentro motivo fundado. Su fianza es $250.
Maria
Okay.
Leon.
María León.
Mr. Leon, Miss Leon, you're charged with petty theft.
Señora León, usted se le acusa de un cargo de hurto de menor cuantía.
Would you like me to appoint the public defender?
¿Quiere usted que yo le nombre un abogado de oficio?
No.
No.
I've looked over the Lake Wells Police Department affidavit.
He revisado el affidavit emitido por el Departamento de Policía de Lake Wales.
Finding probable cause, I'm setting your bond at $1,000.
Encuentro que hay motivo fundado y fijo su fianza en $1,000.
Jonier Perez Quitan.
Jonier Pérez Quitián.
Sí, señor.
Yes, sir.
Sir, you're charged with violating your probation.
Señora, usted se le acusa de haber violado su probatoria.
Would you like for me to appoint the public defender?
¿Quiere usted que yo le nombre un abogado de oficio?
Tengo mi abogado presente privada.
¿Tiene uno?
Sí.
Okay. I have my own private attorney present.
All right, I do show,
Yes,
Devin, our clerk says you have an attorney Vega that's on your case. Do we
La
have an attorney
escribana.
Vega present?
Your Honor,
La-
Destiny Art is covering for Mr. Vega. Sorry, Madam Court Reporter.
Está diciendo la escribana que tiene un abogado, Vega. Hay un abogado Vega presente, su señoría. Estoy representando al abogado Vega.
All right, ma'am, do you have any probable cause challenges based upon the VOP warrant?
Muy bien, señora. ¿Tiene
Your
usted
Honor.
alguna recusaciones de motivo fundado basándose en la orden de arresto de la violación de probatoria?
No, Your Honor, we don't have any probable cause challenges. We do see, however, that it is a violation for hours, and we wanted to ask the state if they would be willing to dismiss and reinstate at this stage because the client still does have a long time on probation and that it was just the 5 hours per month and that was the only violation. So we would ask the state if they would be willing to do that at this stage.
I'm sorry. Su señoría, nosotros no tenemos ninguna recusación de motivo fundado, sin embargo, vemos que esta es una violación que existió por horas y queríamos solicitarle a la Fiscalía si ellos estarían dispuestos a desestimar y restaurar la probatoria en este momento, ya que mi cliente todavía tiene bastante tiempo que cumplir con la probatoria. Y serían 5 horas por mes y solamente fue esa violación.
I believe it was just a lot. I think due to the when the client did plead, due to the language barrier in probation, that just the 5 hours got confusing. But he is willing to the 5 hours. He has more time probation, so we're asking the state they would dismiss the case. And the violation is just reinstate all probation so that way he can complete all of his community service hours.
Your Honor, the interpreter could not understand everything
Yes,
that
ma'am.
was said.
Miss Artis, yeah, we have an interpreter, so if you could pause in between some of your comments and just be aware that your connection's kind of bad also. So
Yeah.
it was kind of garbled. But go right ahead if you want to try to repeat it, but please pause in between sentences.
Yes, Your Honor. Can you guys hear me better now?
Yes, ma'am.
I believe it was some confusion given the language barrier between the client and probation. From what I gathered from Mr. Vega, the client is willing to complete all his probation hours for community service. And he has been in compliance, so we're asking.
Yo creo que hubo alguna confusión dada a la barrera del idioma entre el cliente y la probatoria, por lo que yo puedo entender a partir de lo que me dijo el señor Vega, el cliente está dispuesto a completar todas las horas de su probatoria en servicio a la comunidad y ha estado cumpliendo. Go ahead.
And given the circumstances, we're just asking the state if they'll be willing to dismiss and reinstate.
Y
at this stage.
dadas las circunstancias, estamos solicitándole a la Fiscalía si ellos estarían dispuestos a desestimar y restaurarlo en este momento.
Right, I'm hearing nothing from the state. Ma'am, I do find probable cause for the hold.
Muy bien, no estoy oyendo nada por parte de la Fiscalía y señora, yo encuentro motivo fundado para el arresto.
It is a no bond hold. Looks like it's from Judge Gibson? I believe so. Judge Gibson, who's in the M4 division.
Y parece que es una orden de arresto de retención sin fianza, dictada por el juez o jueza Gibson y que está en la división M4.
Your client's timing is not the best.
El tiempo de su cliente no es el mejor, no fue lo mejor.
And by that, I mean the clerks have him scheduled to see Judge Gibson on June the 8th. Does she have any sooner than that?
Y con eso lo que yo quiero decir es que las escribanas han programado que él vuelva a ver a la jueza Gibson el 8 de junio. ¿No tiene ella un tiempo más pronto que eso?
I'll check to see if the clerks can possibly get him in front of that judge sooner.
Voy a verificar a ver si las escribanas pueden lograr que él tenga una comparecencia en frente de esa jueza más temprano.
Mr. Devon here has said he'll work his magic and get your client in front of the judge on May the 4th.
El señor Devon dice aquí que él va a trabajar y lograr que su cliente comparezca frente a la jueza el 4 de mayo.
Mr. Artist, anything else from you on that issue?
Señora Artis, ¿tiene usted algo más que decir?
All right. So ma'am, I'll hold him no bond and he'll go see the judge next week and you can certainly discuss reinstatement at that time.
Muy bien, lo retendré en la cárcel sin fianza y él comparecerá ante la jueza la próxima semana y con seguridad que usted podrá hablar entonces de volverlo a restaurar en ese momento.
Mr. Hernandez, I think that's everyone. You want to make another announcement?
Sure, Your Honor. ¿Alguien más que necesite español? Por favor, levante la mano.
I see no hands. Mr. Hernandez, you have a great rest of your Tuesday.
You too, Your Honor. Thank you.
All right, everybody, we got through the translator cases, interpreter cases. That always slows us down. We're going to pick up some momentum now. I'll do the gentlemen that are patiently waiting there at South County, and then I'll turn my attention to the ladies at Central and finish up with the men in back. All right, to that end, let's go and call next up Christopher Davis Jr.
Ask to be heard on this one.
Sir, you're charged with burglary with an assault or a battery. That is a first-degree felony punishable up to life in prison. Do you plan on hiring a lawyer or do you want the public defender?
I say public defender, sir.
I'm sorry, sir, I didn't quite pick that up.
So I take public defender, sir.
Okay, yeah, we'll appoint the public defender to represent you. I've looked over your affidavit. I read it back in my chambers, my office, before I came down to the courtroom. I find probable cause. Does the state wish to be heard?
Yes, Your Honor, this is a first-degree felony punishable by life. The burglary is alleged to have been done of a dwelling, so it is an enumerated dangerous offense. The state is requesting the court hold the accused no bond pending further proceedings. If the court is not so inclined, I will request 24 hours to file a motion for pretrial detention. Thank you.
Anything from you, Ms. Smith?
Just ask that a bond be set.
I'll tell you, when I first read the affidavit, I was worried I didn't have much of an assault. It said he walked past him. Oh my goodness, you need more than that. Especially when you're saying get out and you're standing by the door and he walks towards you. But then the deputy went and put a lot of detail after watching the video. And I do believe there's a sufficient basis for the assault based upon the added information. Mr. Davis, I am going to hold you. You exercise my discretion and hold you no bond on that charge. It is something that's allowed to be done that way. So I'll hold you no bond, sir. Have a great day.
All right, sir.
Next up, we have Eric Hollis. Mr. Hollis, you're charged with failing to appear for pretrial conference on a driving while license suspended or revoked charge. Do you want the public defender?
Yes, sir. I think I already had one on the case.
You are right, sir. Mr. Devon made a notation of that. You already have one. I've looked over Judge Cole's capious finding probable cause. He set your bond at $2,000. Yes, sir. You got your hand raised, I think.
Yes, sir. I was incarcerated here at South County at the time.
All right, sir. Have a great day. It's 2,000 cash or surety. Next up, we have Linvent Jones.
Sanders Smith, Platte Defender's Office. I do want to weigh the rating of this one charge, one felony charge that he has.
Mr. Jones, you are charged with a 3rd-degree felony. Do you want the public defender?
Yes, sir, I already got one, Your Honor, Mr. Bino.
Yeah, you might have it for an older charge. This is a brand new charge. So I'll go ahead and appoint the public defender on this one. I reviewed the affidavit before court, finding probable cause, setting your bond at $5,000. Have a great day, sir. Next up, we have Wayne Ricks. Mr. Ricks, you're charged with violating your probation. You want me to appoint the public defender to represent you?
Yes, sir.
This is a Polk County 21 CF case number. Just looks like you might have been supervised in Osceola County. Is how I interpret all this.
It is the Polk County case.
Yeah, Polk County case, but the affidavits from Osceola County Uniform Charging Affidavit. So, sir, tell me again, you want the public defender?
Yes, sir.
All right, I'll appoint them to represent you. It looks like that's my take, is that you had a Polk County probation matter and you're being supervised because you chose to move over to Osceola. Happens all the time, DOC. So I find probable cause based upon this affidavit that I have in front of me. I'm going to hold you no bond. You'll go see the felony judge on May the 26th. Have a great day. Richard Salcedo.
Sorry.
Yes, sir.
Sanders Smith, Platte Defender's Office. We were appointed on his case yesterday, so we've already been appointed. I had a qualified challenge on the one count of the possession of alprazolam. That's the only charge that should be before the court today. I have not received any new police report from the state for probable cause purposes, so I would ask that Mr. Salcedo be, that no probable cause be found and that he be released on his own recognizance on the possession of alprazolam charge.
I received, my office reached out after first appearance yesterday. My colleague sent an email, copied me. To my knowledge, we have not received an updated affidavit or an additional police report, Judge. And so, Andrew, I read the affidavit, and it just, with respect, it just simply seems to mention also Xanax was found.
Yeah. Well, so the judge yesterday read this, and Xanax not being alprazolam, it's the same thing, but I guess that.
If it doesn't say how they identify it to be that, they leave.
Yeah, that's what I'm just asking what your argument was.
Yeah, my argument is that they don't identify it by saying the numbers on the pills, or they consulted www.drugs.com to verify that it is in fact an alprazolam. They have a conclusory statement that it is alprazolam without explaining why they believe it to be alprazolam. That was my argument.
Yeah, I wasn't here, so I don't know. So in your position is that you don't have anything to add to whatever the judge determined yesterday wasn't sufficient?
Correct, Judge.
Okay, so I'm gonna find no probable cause, ROR, the gentleman on that charge. So sir, the downside of that is if you don't bond out, you're not getting any credit for that alprazolam Xanax charge, and then the state still can turn around and charge you with it. So all I'm doing is releasing you from jail on that charge. They get the final say on what you're charged with. So have a nice day, sir.
Salcedo, that means your bonds right now are just $6,000 instead of $11,000. So maybe you can bond out now. So you only need $600 cash to bondsman to be able to get out with collateral versus $1,100. Okay.
Yes, ma'am. Good.
All right, next we have Lori Den.
Miss Den was sent back to her housing unit to see my medical, if we can put her on for tomorrow.
And I was about to say, I apologize, I jumped over Miss Addison, but you're saying that you sent her back for what reason?
Miss Den was sent back due to medical.
So she had a medical issue.
Yes, that's correct.
Okay.
Miss Addison's at the podium, but Miss Den was sent back.
So Miss Smith, just put her on for tomorrow?
Yes, Jonathan.
Yeah, I'll be back tomorrow, so I'll see Miss Den then. put her at the front. Now we can call Alicia Addison. Miss Addison, you're charged with,
I do want to waive the reading of this charge. I would note on the docket, it should be an attempt. It is an attempt charge. It is a first-degree felony. The state attorney did file information on it. I believe she already has regional counsel previously appointed on this case. But it is an attempt.
it is. Yeah, I read it.
Attempt for what?
Yes, ma'am, I'm happy to tell you what it is. Miss Smith doesn't want me to tell you, so if you can read, the deputy's going to show it to you. But the specific charge is count 2 of the 6-count information.
Yes, sir.
All right. That charge is a first-degree felony, punishable up to 30 years in prison. You already have an attorney, court-appointed attorney representing you on this. I'm finding probable cause based upon the information and the habeas. It looks like that charge was previously seen by a judge and has been upgraded by the state. Does the state wish to be heard as it relates to bonds on that new count 2?
Yes, Your Honor. The charge and the attempt for that crime are enumerated dangerous offenses under 907-041-5A. State is filing a motion for pretrial detention. May I approach?
Yes, sir. And Devin, can you tell me when, I assume that Ms. Addison came through the court before on that domestic charge, which was previously count 2, and whatever judge could have been me gave her a bond on that one?
I have a first appearance order from April 5th.
Yeah, I'm just curious. I think it's that new.
I see it here too.
It was Judge Williamson. So ma'am, you came through court before with another judge back in April on the 5th. At that
Yes,
time,
Judge.
count 2 was domestic battery, and that judge gave you a $5,000 bond. The
Yes,
state
sir.
of Florida, the prosecutors read it, reviewed it, they changed their mind, they upgraded the charge to the one that it currently is. And so that $5,000 bond was what you had previously. Mr. Matthews, I didn't mean to cut you off. Go right ahead with any argument on your motion.
At your pleasure, Judge. The state respectfully requests the court review this motion for pretrial detention, and if it is found facially sufficient, that the accused be held no bond on this count, pending a hearing of this motion, which should be set for next Monday, I believe it's the 4th, but at 1 o'clock on the A2 docket. Thank you.
Ms. Smith, anything from you?
No, Your Honor, I didn't get the motion. She has regional counsel on it.
I always turn to you because you're here.
I know.
You know, and you always want to.
I'll look at it. I'm not really a counsel for it, but it looks sufficient to me based on what I just read, the first couple paragraphs.
It is an F1, yeah. The easiest way is always looking at information.
No, I mean, it's not on the case. so.
Shows first degree felony.
Thank you.
So ma'am, I have reviewed this motion for pretrial detention that is based upon the new count 2, the first degree felony. I reviewed it. I find that it's facially and legally sufficient based upon the rule of procedure and the Florida statute 907.0415D. As a result of this, I'm going to hold you no bond on the new count 2. And you'll go see the circuit judge, the A2 judge, on Monday, the 4th at 1 p.m. Have a nice day.
You too.
I mean, it's a no bond. I feel silly at this point. But she got those same pretrial release conditions on everything. That brings us to Elizabeth Easton.
Easton is medically unable to appear at first appearance today.
I'm gonna have to reset it again tomorrow.
Miss Easton's in luck. I've already reviewed it, and I'm the lucky one tomorrow that'll be doing first appearance, and so I've already read it, and I'll bring it back tomorrow. And so I have both Den and Easton that I'll circle to make sure I remember to bring those documents back. Virginia Ellis.
Yes, sure.
Miss Ellis, you're, what we have is you're a warrant from another county, Highlands County. Says here you failed to appear for court on a charge of petty theft. I've
been in Polk County Jail.
Okay, do you want me to appoint the public defender? I'm allowed to do that for a Highlands County case.
I have one there. I've already bonded out there. I was in jail here. I couldn't appear.
No, I heard that. I was just talking to you about step 2, which is the attorney. So if you're comfortable, you already have one, we'll make a note of that. I'm looked over your affidavit and the teletype from the jail down there. I find probable cause. It looks like Judge Rittenhour set your bond at $10,000. Have a great day, ma'am.
Okay.
And if there's nothing else holding her, we'll notify Highlands to come get her. If they have not come get her within a week, we'll bring her back to see a judge.
Yes.
All right, have a great day, ma'am. Alexandra Miller. Miss Miller, you have a total of 9 charges. 7 of them appear on one affidavit. 2 others appear on the second affidavit. For each of these 9 new charges, do you want me to appoint the public defender?
Yes, please.
I'll do that. I'll go ahead and appoint that office to represent you provisionally. I reviewed both affidavits and I find probable cause for all 9 charges. Let's go over the first affidavit. On the charge of battery on a law enforcement officer, there's 2 counts. I'll set your bond at $5,000 per count. On the next charge, it's resisting with violence. There's 2 counts of that charge. I'll set your bond at $5,000 per count on that 3rd-degree felony charge. The next charge is leaving the scene of a crash involving injury. I'll set your bond at $5,000 on that one. Next one is 2 counts of resisting without violence. Those are misdemeanors. Your bond will be $1,000 per count. Turning our attention to the second affidavit, on the charge of DUI, I'm going to set your bond at $1,000. And on your final charge, refusing to submit to a breath test, $1,000. I'm going to make all of those bonds conditions of pretrial release. If you're able to post those bonds, you must immediately check in with the Office of Pretrial Release, sign up in person, and call them on Tuesdays. You have all the standard conditions, plus the following special conditions. You are not allowed to possess or consume alcohol. You cannot go to any bars, nightclubs, or lounges. You'll be subject to random urinalysis that tests for alcohol. Have a nice day, ma'am.
Thank you.
Heidi Reed.
Sanderson Flood Defender's Office. On Ms. Reed's case, I do have 2 stipulations with the state regarding 2 of her charges. On the touching, strike, causing harm to a police or fire dog, and also on the resisting a police canine horse with violence. On those 2 charges, that there is no probable cause and that she should be released on her own recognizance on the 2 documents.
Thank you, Jesus.
Yeah, I noticed there was not a lot of detail as it relates to the canine. Once the canine was sent in, so wasn't a whole lot of detail as to what was done to the canine. But I saw those charges, so I thought.
I did review the statute for each of those. There were 2 different statutes listed, and I did compare those with the affidavit for those 2 counts. And at least at this point, states have agreed.
All right. Ms. Reed, you are charged with, as you stand there, you're charged with 10 counts. Do you want me to appoint the public defender for those 10 counts?
Yes, sir.
I'll appoint that office to represent you. I've looked over the Winter Haven Police Department affidavit from my review of this document. In fact, there's 2 of them. I do find probable cause for all charges with the exception of the 2 that were previously mentioned by Ms. Smith.
Yes,
On
sir.
the charge of battery on a canine, police dog, no probable cause ROR. On the charge of resisting a police canine, no PC ROR. There's probable cause for the remaining 8 charges. Let's go through them one by one.
Yes,
On
sir.
the charge of trespass in an occupied structure, your bond is $2,000. On
Mhm.
the charge Resisting without violence, your bond is $2,000. On the charge of battery on a law enforcement officer, your bond is $7,500. On your bond on the possession of drug paraphernalia, it's $2,000. Possession of meth, $7,500. Resisting with violence, $7,500. And on the remaining two charges, both of them are VOPs. I'm going to hold you no bond. Have a nice day, ma'am.
You too.
Tanisha Williams. Miss Williams, you're charged with resisting without violence and domestic battery. Do you want the public defender?
I don't know what that is, but I guess.
Public defender is a lawyer office with an elected public defender that's elected by the citizens of Polk, Highlands, and Hardee. As an elected public defender, she hires attorneys that are her assistant public defenders who work in courthouses in Polk, Highlands, and Hardee counties, handling everything from felonies to misdemeanors to juvenile. So do you want me to appoint a government court-appointed attorney to represent you?
Yes, sir.
I'll go ahead and do just that. I've looked over your affidavit from the Polk County Sheriff's Office. I find probable cause for these two charges. Does she get, what does her record consist of? I think I saw them.
Misdemeanor.
So she had one pretty good sized charge previously in Polk County. Looked like it was dropped in March. Here we are. Okay. Ma'am, I've reviewed the affidavit from the sheriff here in Polk. I find probable cause for both charges. Your bond on the resisting without is $1,000. Your bond on the charge of domestic violence battery, where you're accused of striking the alleged victim in the nose, that'll be set at $5,000. Those two bonds are going to be conditions of pretrial release. If you're able to post those two bonds, you must immediately check in with the Office of Pretrial Services. Sign up in person, calling that office on Tuesdays. You have all the standard conditions plus special conditions 16 and 17, which says you cannot be in possession of or carry any firearms, weapons, or ammunition, and you can't have any intentional contact with the listed victim. This means directly, indirectly, or through a third party. You must stay 500 feet away from him, his home, his vehicles, where he works, or where he goes to school. I read the comment sheet. It was kind of ambiguous. In one sense, she said he wants contact. The next sentence, he's saying he wants to get an injunction.
Right, I saw that.
I played it safe, and I went with the no contact. Have a nice day, ma'am.
Thank you, you too.
On to the gentleman. First up, we have Luis Estacio.
Your legs looking outside.
Mr. Estacio, you're here for 5 different VOPs. Do you want the public defender?
Yes, yes, Your Honor.
I'll appoint that office. Finding probable cause based upon Judge Harb's warrant holding you no bond. You'll go see him on May the 26th. Have a great day. Austin, actually it's Archie Allen Austin, which appears to be a bringback. Is this a bringback because it wasn't available yesterday, or was there some kind of?
Judge P. He said it for whatever reason.
So he was disruptive.
He did come to court.
You came to court and she just had enough of, it was going south.
They had him marked down as argumentative.
I wasn't. I was told. I only asked because I see that it's a bring back. I just wasn't sure what was the basis. Good afternoon, Mr. Austin. You're charged with felony domestic battery, and the felony is based upon it having a prior conviction. Do you want me to appoint the public defender to represent you?
That would be fine, sir.
Okay, yeah, I'm happy to do that. Like I said, you've seen how it works. I'm happy to appoint a public defender, so I'll do just that provisionally. I looked over the city of Lakeland affidavit. I reviewed it back in my office. I read it in its entirety. Finding probable cause. Sir, going to set your bond at $5,000 cash or surety and make it a condition of pretrial release. So if you're able to post that bond, you must immediately check in with the Office of Pretrial Services here in Bartow. Sign up in person and call them on Tuesdays. I think Tuesdays is fine. You have all the standard conditions that everybody else has, plus the following special conditions. While on pretrial services, you can't use, possess, or carry any firearms, weapons, or ammunition. You also are not allowed to have any intentional contact with the listed victim. This means directly, indirectly, or through a third party. You must stay 500 feet away from him, his home, his vehicles, where he works, or where he goes to school. Now, this affidavit I'm looking at shows that you have a different address than the alleged victim. So that being the case, there's really no reason to allow you to return to that home because it doesn't appear as though you shared a home with the alleged victim. So I think we've covered it all. Have a nice day, sir.
So they're not allowed to come to my home. I'm sorry.
No, I'm not doing anything towards those victims. The alleged victim, I have no control over them right now.
So we have to stay away from each other's residence.
No, you have to stay away from them. They're not, the only thing that, just so you understand, I'm a judge, clearly, but I don't have endless power. I can't walk down the street and say, hey, I'm a judge, y'all, everybody listen up. Sir, no, you can't go around your friend anymore. I don't have that kind of power.
I live at 4509 Orangewood Loop West. They can't come see me at my house.
I don't have the power to tell anybody that they can't just go somewhere that the law allows them to go. What gives me the power to tell you to stay away from them is you're sitting there in orange, you're arrested. That's what gives me the power. They're not charged with anything, so I can't tell them not to go walk down your street or near your house.
Yeah.
You have every right to pursue an injunction, if there's divorces, things like that. Judges can keep you apart, but no, sir, I've done nothing to limit where they can go. Just you, because you're sitting there in the orange. Have a great day.
Thank you. You too, Your Honor.
You bet. Christopher Braswell. Mr. Braswell, you're charged with conspiracy to commit retail theft, and it looks like the charge is larceny, petty theft from a merchant. Do you want me to appoint the public defender to represent you on these two charges?
Yes, sir.
I'll do just that. I've looked over your affidavit as well as another fellow that's there related to this incident. Finding probable cause based upon your affidavit. Going to set your bond on the conspiracy to commit retail theft. That's a felony, punishable up to 5 years in prison. The bond is $5,000. On the petty theft from a merchant, the bond is $1,000. Have a great day, sir.
Thank you, sir.
Yeah. Next up is Reynaldo Cortez. Cortez is charged with false ID to a police officer. Sir, do you want the public defender?
Yes, sir.
I'll appoint him. Finding probable cause based upon LPD's affidavit. Setting your bond. It looks like at the time you had contact with him, you might have had a warrant from another jurisdiction is what it looks like. So I'm going to set your bond at $2,000. Have a great day.
The child support matter?
And I'm also seeing a purchase.
I didn't even have him here for a Highlands County thing.
I think,
He wasn't in the jail list, doesn't show.
it's Highlands County, it's a writ of bodily attachment. I mean, it's not a criminal charge. I would just ask if you could get the standard bond of 1,000 because it's a child support issue, not a criminal.
Well, they don't bring Polk County pickup orders to see the judge. So the only reason again, what threw me is he's not on this list. So if he's not on this list, I didn't prepare. I mean, the pickup order is not on this list. He's on the list with a false ID.
Yeah, it says he has a writ for bodily attachment. It might have been out of Highlands County, so that may be.
No, it is. I'm just saying that, this list, which normally you would think would have those things. Anyway, not a big deal. It's there's no public defender that can be appointed for a writ of bodily attachment. I find probable cause because Ms. Leatherwood did provide me a copy of it. I have it here in front of me, and it looks like there is a purge in place for $400. $400.
This is one still 2,000 on the false ID.
Yeah, yeah. So 2,000 on the false ID and $400 purge. Next up is Christian Koto Sepulveda. Sir, you're charged with domestic violence, battery with a prior conviction, and possession of a firearm by a convicted felon. Do you want me to appoint the public defender? And I couldn't hear you if you said anything. They're muted. Yeah.
Yes, sir.
All right, there you go. I heard that time. I'll provisionally appoint that office to represent you. Sir, I have a warrant in front of me, signed by Judge Patey. From this warrant, I find probable cause for those two charges. She's did not set bonds on either of them. There are no bonds until you have first appearances. So what I'm going to do is I'm going to set your bond on the domestic battery at $5,000, and that's domestic battery with a prior conviction. It's just so we're on the same page. That's punishable up to 5 years in prison as a felony. And then on the possession of firearm by a convicted felon, your bond is $15,000. I'm going to make those bonds conditions of pretrial release. And if you're able to post those bonds, immediately check into pretrial services, sign up with them, and call them daily. You have all the standard conditions of pretrial release plus the following special conditions. You have a curfew of 10 p.m. to 6 a.m. You're not allowed to be in possession of weapons, firearms, or ammunition. You're not allowed to have any intentional contact with the listed victim.
Your Honor, I believe the alleged victim in this case wanted to have no violent contact.
Take it up with Judge Patey.
Okay.
I mean, candidly, that's what the warrant says, and so.
Well, I mean, I believe the warrant, I mean, she didn't have that information that the court now has, and my understanding is that warrants can be changed, the amounts and different conditions. As the capias is, they can't be changed.
I'm about to, I agree with you, because I'm about to change it. By that, I mean, I'm going to put him on GPS monitor.
I mean, so they are subject to change. I was just bringing that up.
Yeah, I mean, the way I look at this, there's an allegation of, try to use the right terms. There we go. That's what I was looking for. She further stated that Christian has been making threats to kill her and shoot her for the past 4 days. Well, I'm not letting her have contact with them. In fact, I'm putting him on a GPS monitor and telling him he cannot have contact with her. Okay. So, sir, you have to call in daily. So I forgot where I was at, Ms. Smith. Go back and start all over, I suppose. Sir, your special conditions are you have a curfew of 10 p.m. to 6 a.m. Can't use weapons, firearms, ammunition, or knives. No contact with the listed victim, directly, indirectly through a third party. Stay 500 feet away from the victim, their home, their vehicles, where they work, or where they go to school. I'm going to order that if you postpone, you must be held in the Polk County Jail until which time as you've been outfitted with a GPS monitor. I'm not putting you on house arrest, so I'm not saying you got to be confined to your home. I'm saying you can't go within 500 feet of the alleged victim, their home, their vehicles, where they work, or where they go to school. I take those death threats, alleged death threats, seriously. So if I don't, for the time being, I don't want you having any contact with her. Things got to settle down. And you and your attorney have every right to go in front of the judge that's assigned to your case, and maybe that judge can revisit the no contact provision and possibly change it to something different.
Yeah, they have the same address, so they live together. Can he get 48 hours with law enforcement if he happens to bond out or able to bond out to get his personal belongings out of the house?
Absolutely. Sir, since you resided with her prior to being arrested, I will allow you to return to that residence that you shared with her one time within the first 48 hours of being released from custody. But to go there that one time within 48 hours, you have to be accompanied by law enforcement to retrieve your essential items such as clothing, medication, and work tools. Have a nice day, sir.
Your Honor, what if she doesn't, what if she moved to her mom's house and we have the same job?
Yeah, if she moved out of that home that you two shared, and if that can be confirmed by pretrial services, Miss Amber sitting to my left, she works for that office. If that can be confirmed through pretrial services, yeah, you get to go back there. I don't want that home to sit empty. But I just don't want you to go within 500 feet of where she lives. Now, you
Yes,
said
sir.
she works with you.
I will be working for the same company.
Do y'all work on the same shift? Is there a chance you're gonna see her
Mm.
while working?
It's up to whoever makes the schedule, sir.
I mean, up until this point, is it normal for you to see
No,
her?
sir. No, sir.
Okay. Well, so what, I don't want you to have any contact with her. I don't know where you work. If you want to tell me where you and her work, I can apply some common sense and maybe lower the 500 feet to something closer together. I still don't want you sitting there chit chatting with her and drinking
Yes, sir.
coffee with her on the job. Okay, so if you want to share with me where you work, I can try to apply some common sense and.
It's fine, sir. They'll probably just put me in a different store.
Okay, so there's a chance you work with the same company but different locations.
Yes, sir.
Okay, there you go. Have a great day, sir.
Thank you.
You bet. Next up, we have Brian Epps. Mr. Epps, you're charged with domestic violence battery with a prior conviction. That makes this a felony. Do you want the public defender?
Yes, sir.
I'll appoint the public defender to represent you. I see that there's a prior conviction. Can you tell me what his record looks like? Recent stuff? How long are we talking about from his priors? So he hadn't been in trouble, look like here since about 10 years ago. Yeah. All right. Mr. Epps, I've read the affidavit from Lake Wells PD, finding probable cause. I'm going to set your bond. I'm going to reduce it from the standard bond for that F3. I'm going to set your bond at $2,500. Make it a condition of pretrial release. If you post bond, you must immediately check in with pretrial services, sign up in person, calling them on Tuesdays. You have all the standard conditions plus the following special conditions. You can't have in your possession weapons, firearms, or ammunition. You can't have any intentional contact with the alleged victim. This means directly, indirectly, or through a third party. Stay 500 feet away from her, as well as the home she lives in, her vehicles, where she works, or where she goes to school. Now, it does appear to me as though you guys lived in the same address prior to your arrest. Now, like the last fella, if the alleged victim has moved out on her own, well, then I'm okay with you going back home. You
Yes,
just gotta
sir.
stay 500 feet of wherever she's at. But if she still lives there and that's her legal residence, you're gonna have to find somewhere else to go, okay? That's just the way it has to be. Even if you're about to tell me, hey, Judge, I pay the bills, I pay the rent, I get it, I understand. But if that's her legal residence, until something changes to cause it not to be her legal residence, then you'll have to find somewhere else to go if she's still there, okay? But I will let you go back one time within the first 48 hours of your release from custody with the police to retrieve essential items like medicine and clothing. Any questions, sir?
Negative.
Have a good day, sir. Anthony Erickson? Sir, you're charged with 3 different VOPs. They're all misdemeanors. Do you want me to appoint the public defender?
Yes, sir.
I'll go ahead and appoint that office to represent you.
Excuse me, Your Honor.
Yes, sir.
I do have proof that I've actually did every 3 things that she's been asking me to do for my probation, and I have no clue why I'm even violated for them, because I have proof for this.
Okay. Mr. Erickson, I'm your judge. I'm the one who signed the warrants, and I'll just tell you that I signed them.
Yes,
Because
sir.
like you said, there's 3 things that Ms. Torres is saying you didn't do.
Yes,
I
sir.
will tell you that, not all VOPs in my eyes are the same.
Yes,
You know,
sir.
It's different if the probation officer is saying you didn't do your community service. Well, that's different than you went out and committed a new crime. So they're not
Yeah.
all created equal. So if
Okay.
it was the committed new crime or you just didn't go see her, I'd probably have
Yeah.
you at a no bond.
No,
But-
it's for drugs and not being for something else as well. But I actually did my drug test and I did my U impact as well. I got proof for that, and I have proof for the other violation as well.
There's 3 of them. I'll just tell you so you know.
Okay.
She says you failed to provide proof of scheduling your substance abuse evaluation. That's 1.
Okay.
Number 2, she's saying that you failed to provide proof of completing your random urinalysis, with your drug test.
Which
in the
I've
months
done.
of January, February, and March when your
Yes.
color came up.
I did tell her that I had no vehicle and I didn't get my vehicle until tax season, which was the beginning of April. And I went to do my drug test and it was all at the courthouse as well.
So you believe you did your drug test in January, February,
It's not
March?
that no, I did not do those because I did not have the money or or a vehicle to get back and forth, like I told my probation officer.
The last one is you violated conditions forbidding the use of non-prescribed controlled substances.
I have
and
my
that
medical
your drug
marijuana
test-
card.
Your drug test from April proved to be positive for marijuana, THC.
Yes, I have my medical marijuana card, Your Honor.
All right, sir. Well, the bottom line is a fine probable cause. Good news for you is you do have bonds. Most people that I've seen today with VOPs, they don't get a bond. I set
Yes,
your
sir.
bond at $1,000 on each case. Have a
Okay.
great day, sir. You'll come to
Thank
see
you,
me.
Your Honor.
Come to see me on May the 27th.
Yes, sir.
Milton Estrada? Mr. Estrada, you're charged with violating your probation on a charge of domestic felony battery. Do you want the public defender?
I have a private lawyer.
All right, fair enough. Find probable cause based upon the Orange County paperwork that's been provided. Looks like you're being supervised out of county on a Polk County VOP case. Find probable cause, going to hold you no bond. You'll go see the circuit judge on May the 4th. Pretty quick turnaround. Have a great day, sir.
Thank you.
Markel Gaskins? Sir, you have 4 different charges. Do you want the public defender?
Yes, sir.
I'll point that office to represent you. I've looked over your Lake Alfred Police Department affidavit, finding probable cause, setting your bond on the following cases as follows. On the charge of driving while license suspended with knowledge, it's $250. On the charge of possession of cannabis, it's $1,000. On the charge of possession of drug paraphernalia, it's $1,000. But the big one is count 4, possession of firearm by convicted felon. That's $15,000. Have a nice day, sir.
Thank you, sir.
You bet. Robert Harris? Sir, you're charged with violating your probation on a stalking charge. Do you want the public defender?
Oh, yes, sir.
I'll appoint him. Finding probable cause based upon Judge Harb's warrant that I'm looking at. With probable cause, he wants you held no bond. You'll go see him May the 26th. Have a nice day, sir.
Excuse me, Your Honor. I got a court date in a different county coming up, May 11th.
Yeah, you're probably not gonna make it unless you, because you're gonna be in our jail. You certainly can call your attorney or your family, so maybe they can get word to the folks over there.
Yes, sir.
Have a great day, sir. Isaiah James?
Good afternoon, Your Honor.
Good afternoon, sir. You have 7 things that you're here for. The first 6, I will call those orders regarding pretrial release on case number 26 CF 2692. The seventh thing is separate. It's a fugitive from justice warrant from the state of Tennessee. Do you want me to appoint the public defender on all 7 of these matters?
Your Honor, I already have a public defender. I just bonded out 2 weeks ago, and I don't even know why they let me go. I bonded out, and they literally said I had a warrant on me, when I went to court. So I literally just bonded out on all of these charges. I'm trying to figure
Yes,
out
sir.
what's going on.
Yeah, Judge Carpenini signed a order regarding pretrial release on April the 21st. So that was a week ago today. And it
Yes.
looks like what he was told on April the 21st is that you failed to comply with your GPS monitor in that you did not charge the battery as instructed, which caused the GPS unit to shut down April 20th from 10:31 p.m., April 21st at 12:56 a.m. for about
Yes,
an hour and 47 minutes. And your
Yes, and
whereabouts were unknown during this time.
I understand that, sir, but I didn't have nowhere to go. They put me on GPS monitor, and I'm not from the state of Florida. I didn't have an address to charge at. I went to the courts 3 times to try to get access or get granted from a judge to go home. They didn't even, my public defender didn't even acknowledge me when I went in the office. So at that point, I was begging for help, and they just allowed me just to crash. That's all. I complied with everything else. I reported Wednesday. I called in. My only problem was not having nowhere to lay my head and charge my ankle monitor. And for all of that, I should have just stayed in jail. That's what I'm saying. Now I have
Yes,
another warrant on me for no reason. I'm just trying to figure out what's next. That's all, sir.
So Judge Carpenini's your assigned judge, and he signed your order regarding pretrial release where he wanted you to be held no bond. So that's what we'll do. I'll hold you no bond on the 6 charges contained in 26 CF 2692. And on the fugitive from justice from Tennessee, I'll hold you no bond, and we'll send you to see the judge to talk about extradition on May the 5th. Now, you already have an attorney for the first 6, but on that fugitive from Tennessee, do you want me to appoint the public defender? I can if you want me to.
Yes, sir. And I just had another question. So you said I come back May the 5th or the 6th?
You come back May the 5th for the
Okay.
fugitive. That's where you talk about extradition, whether or not you agree to go back to Tennessee or whether you want to fight it. The other 6 charges that you just bonded out for, your court date is pretrial on June the 25th.
Okay, so will my bond be reinstated so I can go to Tennessee?
Well, that's between you and your bondsman, but right now you have no bond. So if you can convince Judge Carpenini to give you a bond, then you can see if the bondsman will reinstate it or go back on bond based upon your premium. But right now you're being held no bond on all 7.
Well, how can I be charged again with the same charges that I just got out of?
You're not. You're charged. It's the same charges. You're charged with not following the rules when you got out, which is you didn't charge your GPS monitor. So for 2 hours they didn't know where you were. It's not new charges. It's just you didn't follow the rules when you were out on pretrial services. Have a great day, sir. You can take it up with Judge Carpenini.
Okay.
Next up is Jamari Key.
How you doing, Your Honor?
I'm good, sir. You're charged with 3 things. You're a companion of the gentleman I saw earlier. Mr. Key, do you want me to appoint the public defender?
Please.
I'll go ahead and appoint that office. I've looked over his first and then I've read yours second, but based upon your affidavit, I'm finding probable cause for these 3 charges. Let me go over them and tell you the bonds. On the charge of, like him, conspiracy to commit retail theft, that's a felony. I'm going to set your bond at $5,000. On the charge of petty theft, that's a misdemeanor. I'll set your bond at $1,000. And the one charge you have that he did is tampering with physical evidence. They're alleging that you moved the cameras around to avoid being detected. That's a felony. I'll set your bond at $5,000. Have a great day, sir.
Thank you. You too.
Stuart King is charged with violation of injunction for protection against domestic violence. Sir, do you want the public defender?
Yes, sir.
All right, I'll go ahead and appoint the public defender to represent you.
Okay.
Sir, I'm finding probable cause from the sheriff's affidavit setting your bond at $1,000. I'm
Yes, sir.
going to make that bond a condition of pretrial release. If you're able to post that bond, you must immediately check in with pretrial services, sign up in person, calling them on Tuesdays. All the standard conditions everyone gets, plus the following special conditions. You can't use, possess, or carry any firearms, weapons, ammunition, or knives. You can't have any intentional contact with the listed victim. This means directly, indirectly, through a third party. Stay 500 feet away from her home, her vehicles, where she works or where she goes to school. And you also have to 19, do not violate any terms of any injunction currently in effect. Have a nice day, sir.
Sure.
19 was hiding from me. I was looking lower. Jose Luviano,
Sanderson Put Defender's Office. Alleged victim does want to have no violent contact with them.
Mr. Luviano, you're charged with 4 crimes. Do you want me to appoint the public defender?
Yes, Your Honor.
I'll appoint the public defender to represent you. I have looked over this affidavit from the sheriff. I do find probable cause for the 4 charges. Can you pull up that? I don't know if I was aware of that. It is right. You're right. I do have it. Do you object? No. All right, sir. Having reviewed the affidavit from the sheriff and finding probable cause, I'll set your bond on possession of cocaine at $5,000, on possession of drug paraphernalia $1,000, on the battery, the simple battery $1,000, and on the domestic battery $2,500. I'll make those bonds conditions of pretrial release. If you're able to post those bonds, immediately check in with pretrial services. Sign up in person, calling them on Tuesdays. You have all the standard conditions plus the following special conditions. You're not allowed to have firearms, weapons, or ammunition in your possession. You are allowed to have contact with the alleged victim, but this contact is prohibited from being physically or verbally threatening. You can't be violent or abusive in any manner whatsoever.
Okay.
Have a great day, sir.
Thank you.
Tahari McDougal is charged with a warrantless BOP for a charge of burglary of a dwelling. Do you want the public defender?
Yes, sir.
I'll appoint them. Finding probable cause based upon your PO's affidavit. The PO alleges that you tested positive for methamphetamine. Oh, I'm sorry, admitted to using methamphetamine. So I'll find probable cause, hold you no bond. You'll go see the circuit judge on the 26th. Have a great day, sir.
The 26th of what?
Is that this one?
I
think May, that's May 26th. Yeah, yeah. We'll see that.
think we're up to LaDavanette Sinette.
Sanderson Put Defender's
Yes, sir.
Office. Alleged victim does want to have contact with Mr. Sinnott.
Sir, you're charged with domestic battery. Do you want the public defender appointed to represent you?
Okay.
Yes, sir.
I'll appoint that office. I've looked over the sheriff's affidavit back before court started, finding probable cause. What does it look like as far as record? Much of anything? Minimal. This one is still up, but okay. All right, so you said victim comment, they do want she does want contacts. Has no prior history.
Other than one addition.
But it was dropped.
Yes, sir.
No convictions. All right, Mr. Sinet, I'm going to straight pretrial release you. That means
Yes,
you
sir.
don't have to post any money, but you're
Yes, sir.
promising on court when I tell you to.
Yes, sir.
So I'm gonna straight pretrial release you. If you're able to post, when you get released, you have to immediately check in with pretrial services.
Yes, sir.
With them in person. Call them once a week while your case is still active, and that'll be on Tuesdays. You have
Okay.
all the standard conditions of pretrial release that everybody has, plus the following special conditions. You can't use, possess, or carry any firearms, guns, weapons, ammunition, or knives. So that's a big no-no while you're on pretrial, okay? You can't have any weapons around.
Yes, sir.
You are allowed, and this is because the alleged victim's told pretrial that she wants to have contact with you, that based upon her wishes, I am going to allow you to have contact with the victim. But this contact is prohibited from being physically or verbally threatening. You can't be violent or abusive in any manner whatsoever. If
Yes,
you
sir.
were to be violent or abusive verbally or otherwise, going to find yourself right back in jail because you would violate your pretrial conditions, okay?
I'll just leave if it came down to it as we go.
There you go. Leave, take a walk, do something to cool down and don't get yourself in that situation.
Yeah, so
All right.
so with the so how long does it take for me to get released, if I may ask?
That's between you and the deputies in Green, but I think they're going to try to get you out of there, this evening. So you
Okay.
won't be able to go to pretrial today. You'll probably be after hours, after work hours. So you'll
Okay.
have to do it first thing in the morning and sign up with them here in Bartow. But
Yes,
just
sir.
make
But-
sure you don't have weapons. Make sure you call them on Tuesdays. Make sure you behave and you don't do anything violent towards the alleged victim.
Yes, sir.
Have a great day, sir. Next up is Dante Sylvain. Sir, you're charged with violating your probation on a DUI. Do you want the public defender?
That's why I can talk for one.
You
Do I
want
want
the
to
public
talk?
defender?
No.
All right. If you change your mind, you can always ask at any time. Finding probable cause based upon Judge Gibson's warrant. She wants you held no bond. I'll hold you no bond. You'll go see her on May the 5th, Cinco de Mayo. Have a great day, sir. Little Tommy Tucker.
Ask to be heard on this one.
Sure. Mr. Tommy Tucker, you're charged with 6 crimes. They are burglary with an assault or battery, 2 counts of aggravated assault, 1 count of resisting officer without violence, 1 count of possession of methamphetamine, 1 count of paraphernalia. Do you want the public defender?
Yes, sir.
I want that office to represent you. I looked over your affidavit from the Lake Wells Police Department, finding probable cause. Mr. Matthews, you want to be heard?
Yes, Your Honor, with regard to the burglary with an assault or a battery, that is a first-degree felony punishable by up to life. That is an enumerated dangerous offense. The allegation is the burglary was of a dwelling. The state is asking the court hold the accused no bond. If the court is not so inclined, the state will respectfully request that he be held until tomorrow to file a motion for pretrial detention. I'd also respectfully note that if the court is not so inclined, but also ask that he be held on the aggravated assault counts, as they also are enumerated dangerous offenses, and I would ask to address them in a motion for pretrial detention if it is filed. If he is held no bond on the PDL, then I leave bonds to the court on those.
What is it? He's got an open case. What are the charges in the open case?
Felony battery, prior conviction, and we are asking for a Parker hold on that as well.
All right. Ms. Smith, anything from you on
No, Your Honor.
Mr. Matthews' request? Okay. Sir, having found probable cause, I'm going to set your bonds as follows. On the charge of possession of meth, it's $7,500. Paraphernalia is $2,500. Resisting without is $2,000. Each of the 2 counts of ag assault will be $7,500. And on the burglary with an assault or battery, I'm going to hold you no bond. If for some reason you're able to bond out down the line, you'll be on pretrial release, which means if you post bond, you have to immediately check in with pretrial services, sign up in person, calling them on Monday, Wednesday, Friday. Monday, Wednesday, and Friday, all the standard conditions plus special conditions. 16, 17. Yep, I like those. and I am going to revoke your bond pretrial release on the case that's outstanding. And that'll be, 25 CF 10679. I'm going to hold you no bond pursuant to the authority of Parker versus State. You had a question? Oh, yeah, no, okay, that's fine. Him being the last one, I wasn't willing to yank him back in. Have a nice day, sir. Now, Smith, I know we have, and even though he used some less than ideal language, I wasn't willing to let him.
I appreciate that.
Let him go over there and regroup. I heard there's going to be a adverse preliminary hearing, or is that status conference?
I think it's for tomorrow, some sort of, I'll tell you about it tomorrow. It's on the 29th. It's not today.
I'm sorry, Ms. Leather was sending along with me thinking it was today, but yeah, it's an adverse preliminary hearing.
I'll email you about it once I remember it again.
That's setting the hearing.
We just set the hearing, or I'll email you